Good afternoon, Miss Macleod. Will you take the oath?
Yes.
I swear by Almighty God
I swear by Almighty God
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Thompson.
Good afternoon. You are Michelle Macleod.
Yes.
And you are the Police Investigations and Review Commissioner.
Indeed.
May I ask your age?
Yes, I'm 59.
Before I ask you any further questions, can I invite you to take a look in the blue folder that's in front of you? I can see you have already opened it up, just so that we can have a look at the documents that are in it. I'm aware that you have sat through a lot of evidence before the inquiry, and so you will appreciate that we will have a copy of your statement within the folder and other documents that we think you might find it helpful to refer to. So we should find within the folder the Rule 8 request that the inquiry sent to you on the 5th of April of 2024. We don't need that on the screen, but the reference is SBPI 00617. Is that there in the folder, Ms. Macleod?
It is, yes.
And we should also hopefully have in the folder the response that you submitted to the inquiry dated the 25th of October 2024. And this we will bring up on the screen. It's SBPI 00551. If we scroll through this document, I think we'll see that it incorporates the questions that you were asked along the way, but as we scroll through, please, we will see that your answers to the questions you were asked are set out in full. So if we pause here, we see, for example, that the first question that you were asked was in relation to your professional experience before you became the PIRC, and we see that you've outlined there your experience in the Crown Office. So although the first page bears to be a letter sent to you by the solicitor to the inquiry, you have filled in your answers to the questions that were asked of you. Can we go to the very end of this document, please? There's an appendix on the very last page or so. If we can go to the numbered paragraphs, there we are. We can see that there are 39 paragraphs to the Rule 8 response. And paragraph 38 invited you to include certain wording before you signed the statement which you have done. And that wording reads, "I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website." And although your signature has been redacted on the screen, hopefully your signature will appear in the version that's in hard copy in your folder.
Yes.
And you signed the statement on the 25th of April of this year, and you did so in the knowledge that the statement may form part of the evidence before the inquiry and be published on the inquiry's website. And when you answered the questions that were asked of you, did you do your best to answer the questions fully and accurately?
Yes.
Now, technically, this is a response to a Rule 8 statement, but by way of shorthand, I'll probably refer to it, a Rule 8 request, I'll refer to it as your statement. If you want to refer to your statement at any time, Ms. Macleod, you can do so. From time to time, I might ask for passages to be put up on the screen, and when you're responding to questions, if there's any passage that you would like me to bring up on the screen, please just say, and we can arrange for that to be done.
Thank you.
There should be a third document within the folder. There should also be a set of guidelines issued by the PIRC, and these are guidelines for dealing with allegations of discrimination when undertaking investigations and complaint handling reviews. We will look at these in detail later, so we don't need them on the screen just now, but for completeness and for the benefit of those behind me, those are PIRC 04724. And again, I'll ask for certain passages from those guidelines to be put on the screen, and if there's anything you would like to draw to our attention, please say, and we can bring it up on the screen in front of us. But you can refer to these documents at any point in time if you would find that to be helpful.
Thank you.
I want to begin by asking you a few questions about your professional experience. Now, there's considerable detail of your career in the statement which you have prepared, which is, of course, available to the chair. He can consider your statement at his leisure, and so I'm going to move through your CV quite quickly. And I think we can do this without the need to bring your statement up on the screen, but I will give the paragraph references for the benefit of those following your evidence. You explain in the first paragraph of your statement that you were employed by the Crown Office and Procurator Fiscal Service for more than 20 years,
Yes.
from 1992 until 2013, that you entered the service as a trainee solicitor, and that you remained in post as a Procurator Fiscal Depute after you qualified. And as your career developed, you held ultimately a number of senior civil service positions within the Crown Office, including being the Area Procurator Fiscal for Edinburgh, the District Procurator Fiscal for Linlithgow and Interim District Procurator Fiscal for Edinburgh, the Area Fiscal for Central, Head of Policy, and latterly the Procurator Fiscal for High Court East.
Yes.
You also explain in the first paragraph of your statement that in 2013 you moved away from the Crown Office and you were appointed as Her Majesty's Chief Inspector for the Inspectorate of the Prosecution in Scotland, and you held that post for 6 years, from 2013 until 2019.
Indeed.
And you explained too that it was your responsibility to inspect the Crown Office and to make recommendations with a view to making the Crown more accountable and so to enhance public confidence.
Yes.
In the second paragraph of your statement, you explained that you were appointed as the PIRC, that is the Commissioner, in 2019, and you set out the challenges that you faced upon appointment. You explained that in addition to familiarising yourself with the role, the remit of the organisation and its staff, there were a number of challenges, including the impact of the pandemic, the need to respond positively to criticisms of the PIRC and Lady Angelini's preliminary report on complaints handling and investigations and misconduct, and also the requirement on the PIRC to investigate the fatal shooting of an asylum seeker in a Glasgow hotel, which you describe as being a significant PIRC response and a time-consuming and labour-intensive investigation.
Indeed.
Again, all of these challenges are set out in some detail in your statement, which is available to the chair. You explain that the impact of these challenges was that you were 2 years into your tenure as Commissioner before you could properly address the priorities for the development of the organisation that you might otherwise have turned to sooner.
Yes, in relation to that, one of our limitations was that when the pandemic struck, we had no video conferencing facilities. Whilst we got some, I think it was Skype in the following months, it wasn't until the end of 2020 we actually got MS Teams and were able to then have proper video conferencing facilities, which allowed us to have, again, not face-to-face, but meetings where we could actually visibly see people. So there was obviously a lot of my time during that period of time, like leaders of most organisations, was mainly around business continuity and making sure the staff were safe and staff well-being. So there was obviously a considerable amount of work and effort going on in that, but it was quite difficult without the video conferencing. That made a huge difference when we came to the end of 2020.
Of course, thank you. I'd like to move away from your resume and ask you some questions about the PIRC guidelines on investigating allegations of discrimination. Mm-hmm. And you explain in your statement, and this is at paragraph 10.2, that there is guidance available on investigating discrimination allegations and that the requirement for the PIRC to ensure that discrimination issues are considered as an integral part of the work of PIRC was a recommendation in Lady Angelini's report. I've read out that reference, but I see you looking through your statement, so let's bring it up on screen just to get our bearings. If we can turn to paragraph 10.2, please. So this is on page 11. Here we are. Thank you. So you explain here that there is guidance available on investigating discriminatory allegations, the requirement for PIRC to ensure that discrimination issues are considered as an integral part of the work of PIRC was a recommendation of the Angiolini report. The guidance on investigating discriminatory allegations were prepared taking account of similar guidelines in the IOPC. The guidelines were issued in November 2021. Prior to publication, the guidelines were shared with Police Scotland Professional Standards Department's Equalities Forums and the SPA for review and comment. They were published on the PIRC intranet with a staff message. An operational instruction was issued in April, reminding all investigators of the importance of referring to the guidance when dealing with any allegations of discrimination. So you explain here that these guidelines were published in response to one of Lady Angiolini's recommendations, and we'll look at that recommendation in a moment, but to put it in context, the report that you refer to here was her independent review on police complaints handling investigations and misconduct issues from 2020, and I understand that the preliminary report, or preliminary report, was published in June of 2019, yes, and the final report almost 18 months later in November 2020. And you explain, and this is in paragraph 14 of your statement, we could perhaps scroll down to paragraph 14. You explain here that although you were not in post during the early stages of Lady Angiolini's review, you understand that several PIRC employees, including the former commissioner, and that was Kate Frame, I believe, were interviewed by Lady Angiolini and her team, and once in post you were interviewed on 2 occasions, September 2019 and August 2020, and you provided written submissions in relation to specific questions and areas raised by Lady Angiolini's team regarding your views on the initial findings and recommendations of her preliminary report.
Yes.
You also explain at paragraph 15, you were asked what was the PIRC's response to the report. Reading this paragraph short, you say that PIRC welcomed the report. And you go on to draw attention to the praise that Lady Angiolini gave to the PIRC in terms of the people, the skills and the values of integrity, impartiality and respect. And you say that was a confidence and morale boost for staff. And you also explained that as Commissioner, you were one of the partners of the Strategic Oversight Group, along with Police Scotland, the SPA and COPFS. You were tasked with progressing the recommendations at a strategic level, and in addition, you were part of the ministerial group, which had oversight of the progress of the recommendations. And if we could look at paragraph 16, so far as implementation is concerned, you've explained that where the PIRC were the lead partner, they have implemented all recommendations that don't require legislation, and you're confident that the recommendations implemented have achieved the intended outcomes. Before we go any further, perhaps you could explain what you mean by the lead partner in relation to a recommendation.
Yes, there was obviously, I think, 81 recommendations. There were a specific number of recommendations, about 30, that related, were directed towards PIRC. There were some that were joint recommendations, but the ones I'm talking about where it was directed are the ones that was directed primarily to PIRC to take them forward.
And you say that the PIRC has implemented all recommendations not requiring legislation. How many require legislation to be progressed?
The ones requiring legislation are now being taken forward in the Police Ethics and Conduct Scrutiny Bill. They don't necessarily marry up what's now in the bill and how many the recommendations were. There's been a transition between the actual recommendations and what's in the provisions in the bill, so they don't actually, I couldn't actually tell you how many legislative ones there were, but all the non-legislative were completed last year.
And those that require legislation, you say that legislation is now in progress.
It is.
To the extent that there is now a bill.
There is.
Thank you. So let's look now at the recommendation that Lady Angiolini made that prompted the creation of the PIRC guidelines. And I wonder if we can pull up Lady Angiolini's 2020 report. That's SBPI 00501. And this should be page 235 of the PDF. If we could scroll down to paragraph 14105, please. Diversity and discrimination. The PIRC should ensure that discrimination issues are considered as an integral part of their work. A systematic approach should be adopted across the organisation, and in all cases, investigators should consider if discriminatory attitudes have played a part. And if we can scroll down to the next paragraph, please. I have raised with the Commissioner the question of guidance available to PIRC investigators. She has confirmed that PIRC does not currently have any specific guidance for investigations on race and discrimination, but is planning to adapt the IOPC's guidelines for handling allegations of discrimination for their own use. So the Commissioner referred to there, that would be yourself, not your predecessor. No. And you had advised Lady Angelini that the PIRC didn't currently have specific guidance for the investigations of race and discrimination, but was planning to adapt the IOPC guidelines. And if we can scroll to what I think should be page 254 of the PDF, please, so that we can see the actual recommendation. Perfect. So this is recommendation 14169. The PIRC should ensure that discrimination issues are considered as an integral part of their work. A systematic approach should be adopted across the organisation, and in all cases, investigators should consider if discriminatory attitudes have played a part. And so the guidelines were a response to this particular recommendation.
They were, yes.
Can we take it then that they're intended to ensure that discrimination issues are considered as an integral part of the work of the PIRC, and that in all cases investigators should consider whether discriminatory attitudes have played a part?
Yes, that was the intention.
And when the recommendation says in all cases, does that mean literally every case that is investigated by the PIRC, or does it mean every case in which an allegation of discrimination is made?
I think in the guidance to staff, it was a general guidance about being live to the potential of discrimination, and if there was particular allegations, this applies to the review side of the business as well, not just investigation, then they should have regard to these guidelines before undertaking the investigation or the complaint handling review. But it was to all the staff were to have a general awareness of the guidelines and have regard to them.
Is there an expectation then that staff should be live to the possibility of discrimination, even if a formal complaint about discrimination hasn't been made by the complainer or next of kin in the case of death?
I suspect at the time it was more directed towards where there was an obvious concern raised, either in the complaint or in the investigation, and where perhaps the victim or complainer, or if it was in relation to an investigation to a death, the deceased came from a minority ethnic community.
Thank you. Who drafted the guidelines?
So as indicated, they were predicated on the existing guidelines by the IOPC, and in that regard I had spoken with the then director at the time of IOPC and asked his consent for us to adapt them for our own legislation and PIRC practices and procedures, and that was granted. I was aware that they had been through quite a number of levels of quality assurance in the IOPC, so it seemed sensible to take them as a starting point. I initially asked Mr. McSporran to go through the guidelines to ensure that the legislation was relevant for Scotland. At that time, I didn't have an in-house solicitor myself, and also to reflect PIRC practices as opposed to the practices, IOPC practices, and we have quite substantial differences. So once that was done, basically I edited the guidelines and I incorporated some PIRC examples and I left some of the IOPC examples, generic examples in there. And yes, it was largely myself, but it was very much taken and amending existing guidelines that were there.
Okay. Let's have a look at the guidelines now. They're PIRC 04724. As I mentioned earlier, Ms Macleod, there is a copy in your folder if you find it easier to work from hard copy. Let's begin at the beginning with the front page, please, and if we scroll down, we'll see that these are the PIRC guidelines for dealing with allegations of discrimination when undertaking investigations and complaint handling reviews. Should we understand that the title of the guidelines reflects these two separate
Yes.
functions of the PIRC to carry out investigations, and that would include investigations at the direction of the Crown, for
Yes.
example, and also their role in carrying out reviews of the way that complaints have been handled by Police Scotland or the SPA.
Exactly.
So these are two separate functions, but these guidelines apply to allegations of discrimination, whether those allegations manifest themselves in the course of an investigation or a complaint.
Yes.
Now, the final page suggests, I think, that these guidelines were published in November of 2021. I think that's page 48, if we can quickly scroll to the end, please. Here we are, version V2, summary of last modification, first draft version, modified by yourself, I think, on the 3rd of November 2021. Can you help us to understand which version these are? When were they first published?
These are the November 2021. Yes, these are the ones that were initially published. We actually, I see there's a review date. They weren't reviewed in 2022, but they're actually subject to review at the moment to incorporate new, the new hate crime legislation. So they're currently being revised at present. With a view to actually updating them and making sure we've got all the up-to-date legislation included in them.
Okay. So this is the first version. Yeah. Okay. And V2, then that's not of any particular significance.
Mr. McSporn did a draft, and then the version 2 is mine, as the final version.
I see. So the last modification, we see first draft version. So Mr. McSporn prepared a draft that would have been V1.
Yes.
You revised that draft, that is V2.
Yes.
But V2 was the first published version.
Yes.
Published in November of 2021. And you've explained that although there was a review date 12 months hence, that didn't happen, but there is now a review underway. Why wasn't there a review in November 2022?
Partly in October 2021, as a result of one of other of Lady Angeline's recommendations, we experienced a substantial increase in our workload, and effectively there was the capacity to do this was limited at that time. I am now, I have an in-house legal staff, and that enables us to do things and review the policies in accordance with our desired timetable. But I think at the time there just was a lack of capacity to review it.
Thank you. Can we return to the top of the document, please? And just for the avoidance of doubt, should we understand that prior to November 2021 there were no guidelines, certainly no written guidelines available to the PIRC as to how to approach allegations of discrimination?
No, not that I was aware of any.
If we could scroll, please, to the beyond the contents page to what I think is page 3 of the PDF, the Commissioner's forward. And you acknowledge here at the outset that it's crucial for public confidence in the independent investigation and review of complaints that allegations of discrimination against the police are handled properly. Values-based policing, which reflects and represents our communities, is vital to secure the consent from which policing draws its legitimacy. Unfair or unlawful discrimination fundamentally undermines the ability of policing to operate by consent. And you go on to explain or to acknowledge in paragraph 3 that investigating and resolving allegations of discrimination can be challenging. Nonetheless, the police complaints system and those who review the handling of police complaints or undertake investigations into the actions or omissions of the police, including criminal allegations, must be able to meet this challenge to retain the confidence of all communities and groups. And you conclude by saying that the guidelines set the standards that complainers, nearest relatives and other interested parties should expect from the PIRC when allegations of discrimination are made against the police. They're also the standards that you will apply when conducting your investigations and complaint handling reviews. If we can move through the document, please, to chapter 1, which we'll find on page 4. And it's headed up Professional Standards and Ethics. And I wonder if we might just look at the first paragraph here. The framework that sets out standards of police officers and staff behaviour includes the Convention rights incorporated into the Human Rights Act 1988, Police Scotland's Code of Ethics, and Police Scotland's Standards of Professional Behaviour. The Code of Ethics is based on the values of integrity, fairness, respect, and human rights. It specifically provides that constables act with fairness and impartiality and do not discriminate unlawfully or unfairly. And if we could perhaps move to the next page, page 5. And at the very bottom of page 5, there's a definition here of a complainer. And you say the term complainer is used throughout these guidelines. However, the same principles apply to nearest relatives or other interested persons in relation to investigations into death or serious injury or other serious incidents or any matters raised in respect of reviewing the handling of complaints. So should we understand then that in the context of, let's say, a death following police contact, where the language complainer is used in the guidelines, the principles apply equally to liaison with next of kin and to their rights and interests in the investigation. Can we move on to the next page, page 6, please? This is chapter 2, and chapter 2 asks the question, what is discrimination? And it begins with the Equality Act 2010, and says that the Act defines unlawful discrimination and specifically prohibits discrimination relating to the protected characteristics, which are listed in full, but perhaps of particular relevance for our purposes. We see that those protected characteristics include race, which in turn includes colour, nationality and ethnic or national origins, and also religion or belief, any religion or religious or philosophical belief, including no such religion or belief. And if we might scroll to the bottom of the page. So this chapter of what is discrimination begins with the Equality Act, and then at the bottom of the page highlights again that the standards of professional behaviour say that police officers must not discriminate unfairly. So there's the legislative framework, then there are the standards of behaviour in addition to that. And if we could perhaps move on to page 7, having looked at the legislative framework and the standards of behaviour, the guidelines then go on to consider the human rights angle under the heading Discrimination and Human Rights. And I wonder if we can look at this because we've heard quite a lot of evidence about Article 14 in recent weeks. Article 14 of the European Convention on Human Rights also provides protection from discrimination. This protection only applies where it is alleged that discrimination has affected a person's ability to enjoy one or more of the other human rights set out in the Convention. For example, Article 14 would apply if an allegation was made that discriminatory actions led to a death in custody, as a death in custody would engage Article 2, the right to life, and also if there was an allegation that discrimination played a part in an allegation of inhuman or degrading treatment, Article 3. For the purpose of Article 14, discrimination is when a person is treated less favourably than another person in a similar situation. and the treatment cannot be objectively and reasonably justified. The application of Article 14 extends beyond the protected characteristics in the Equality Act, and so it may apply to complaints or conduct matters that involve allegations of unfair discrimination, as well as those that involve allegations of unlawful discrimination. Now, a number of witnesses in recent weeks have agreed with a number of propositions drawn from the case law on Article 14, and they have agreed that when there is a death at the hands of state agents, taking Article 14 in conjunction with Article 2, the state authorities have a duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in events, and to pursue that investigation with vigour. But would you agree with those principles?
Yes.
Okay. And would you also agree that the PIRC are subject to that duty?
Absolutely.
So this chapter then looks at the statutory framework, the Equality Act. It draws attention to the standards of professional behaviour, which require that officers must not discriminate unfairly. And then it concludes by looking at discrimination from the perspective of the ECHR, and draws attention to Article 14 and also, for our purposes, Article 2. If we carry on to the bottom of this page, we see that this particular chapter then goes on to set out tests for discrimination, direct discrimination, and later on indirect discrimination, but I'd like to focus on direct discrimination. And it begins with a definition. Direct discrimination is when someone is treated less favourably than another person because of a protected characteristic or characteristics. The key elements of this test are less favourable treatment. This means being treated differently or worse. It is not necessary to show actual harm. It only needs to be shown that it is reasonable that the person would prefer not to have been treated differently in that way. And if we can carry on, please. Less favourable treatment suggests a comparison, i.e. less favourable than who. The who is a person in the same situation who does not have the same protected characteristic. For example, you might compare the treatment of a black person to how a white person would have been treated in the same circumstances. Making this comparison is a key part of the investigation or review. Because of a protected characteristic, this means that the characteristic needs to be a cause of the less favourable treatment, but doesn't need to be the only or even the main cause. Discrimination may relate to more than one protected characteristic, e.g. race and religion, or gender and sexual orientation. And in determining whether there has been direct discrimination, the question to ask is, would the person be treated in this way but for their protected characteristic? And so the guidelines suggest that the process that requires to be gone through involves a comparative exercise, where you might compare how an individual has been treated and how a person who doesn't possess the protected characteristic might have been treated in similar circumstances. And the example that is given in the guidelines is that you might compare the treatment of a black person to how a white person would have been treated in the same circumstances. I wanted to ask you, because you have had a hand in the drafting of these guidelines, and because you are the PIRC, and because you've given an example here involving a black man, if the allegation were one of excessive use of force against a black man, perhaps involving batons, sprays and restraint, how do you anticipate that PIRC investigators would go about carrying out that comparative exercise? What sort of evidence would they need to gather in order to allow them to carry out that comparison?
Well, I think in relation to an investigation, I think it's been discussed in the inquiry. You'd be looking at, for example, were there other options available to the police, were there de-escalation options that they could have undertaken, and you'd be looking whether, for example, they had gone to use of force prior to being absolutely necessary in that characteristic. And that is one aspect of looking at basically basically looking at the conduct of the police officers. I should say that the guidelines were obviously made are adapted to reflect Scottish procedure and PIRC, but the bulk of the actual text came from the IOPC guidelines. And I think, as you've already alluded to, and I won't pretend I was an expert in race, that was why I asked specifically for them to be quality assured by the Police Scotland's Equality Forums, and I did get back substantial feedback from them, which was really helpful, and I took that on board and amended the guidelines to reflect that. So I would just caveat it with that's the starting point, and that's where I went to get quality assurance. But at the time, I certainly wasn't an expert in the guidelines, but we took the best we could at the time.
So you say that if the allegation was one of excessive force against a black man, then you might anticipate that the PIRC investigators would consider what other use of force options were available to the attending officers. De-escalation, was that considered, was that tried, and whether the use of force was selected as an option before other avenues had perhaps been exhausted, before it was necessary to use force. As part of that comparison, because as is identified in the guidelines, the who for the purposes of this comparative exercise would be a white person. Would you anticipate investigators considering whether the officers in question had perhaps used a similar level of force against white subjects in similar circumstances?
The same considerations would be applied in relation to actually any case that we were investigating. We would be looking at those factors to determine whether the actions of the police were lawful, proportionate and necessary. So that's a factor that would be taken into account in relation to any investigation.
Thank you. Let's carry on moving through the guidelines. If we can go to chapter 3, which begins on page 12, please. Sorry, up a bit to page 12, please. Top of page 12. Lovely, thank you. Engaging with the complainer. Discrimination complaints will often involve a complainer who already has very low levels of trust in the police. Failure to engage effectively and empathetically is likely to undermine confidence in the PIRC complaints handling review process or investigation. To build and retain confidence, the investigating or review officer should follow the principles set out below. And sorry, if we could possibly go back to the top of page 12. Lovely. Up a little bit, please. Thank you. So this chapter is headed engaging with the complainer, but should we take it from what you said earlier and from the definition of complainer earlier in the guidelines, that in the context of a death following police contact, we should read engaging with the complainer as engaging with the next of kin? Okay. And the same principles will apply.
Yes.
So whether you're dealing with a complainer or perhaps the family of a person who has passed away, there's a recognition that a failure to engage effectively and empathetically can undermine confidence in the process, and that in order to build and retain confidence, a number of principles are put forward that are recommended to investigators. Let's look then at the advice that is given to investigators. And if we look at the heading, contact the complainer at the beginning of the investigation to establish a clear understanding of the allegation. For our purposes, I think the inquiry is perhaps more interested in the investigation side of things than the complaints side of things, so I might miss out the odd word to bring focus to the investigation side of your functions. In relation to an investigation, it should seek to ascertain why the complainer feels that they have been discriminated against. In particular, it should be explored whether the person felt that assumptions had been made because of any protected characteristic, and why the person believes that they were treated differently. Again, if we can read next of kin for complainer in the context of a death following police contact, should we understand that following the death, for example, of a black man, following police contact, where the family have expressed concerns that race may have been a factor, then the guidelines would require an investigator to make contact with the family to establish why they felt that race was a relevant factor, whether they felt that assumptions had been made, and why the family felt their loved one had been treated differently.
Yes.
Can I ask who you would anticipate being in contact with the family? Would that be a flow?
Yes. In the first instance, it would be the flows that would have that contact.
You say in the first instance, would there come a point where an investigator who isn't a flow would become involved? Because we've heard that flows are first and foremost investigators. They can serve both functions.
It would depend on the individual investigation. It may be at some point in time it would be appropriate for the senior investigator to meet with the family and give them an update on the progress of the inquiry. It may be that the director of operations would meet. It would depend on the circumstances and what the family were looking for to some extent.
Thank you. Can we move on to chapter 4, please, which we'll find on page 16 of the PDF? This chapter is headed Understanding the Allegation of Discrimination, and I'd like to go through this in a little detail. It explains that discrimination can be overt and expressed as open hostility or use of offensive, degrading language. However, it is more than just these things. Direct discrimination includes actions that are informed by biased assumptions or prejudice in respect of a protected characteristic, even if this is done unconsciously. An investigation into this type of allegation will need to test whether discriminatory assumptions, prejudice, or bias impacted on police actions or behaviour. To do this, the investigating or review officer will need to have an understanding of what these discriminatory assumptions might be. If we scroll down a little, there is a heading, What does the complainer say? It is essential that the investigating or review officer takes time to understand why the complainer feels they have been discriminated against. This should include exploring any prejudiced assumptions the complainer feels the police made about them. And again, we would substitute next of kin for complainer in the context of a death following police contact. Further down the page under the heading, What do you know? The guidelines suggest, are there any stereotypes or common assumptions made about the protected characteristic group that you are aware of, which might be relevant to consider? Does this complaint fit with a pattern of previous complaints about similar issues? Is there anything about the policing context in the area or beyond, e.g. relations between police and relevant local communities, any high levels of particular types of crime or recent tensions or significant events, which may impact on or inform these types of assumptions? Where the guidelines say, are there any stereotypes or common assumptions made about the protected characteristic group that you are aware of? Does that suggest that here you're inviting investigators to draw on their own experience of life and potentially their experience within policing, the PIRC, and any training that they've received to put forward, as it were, their own understanding of stereotypes and assumptions that are potentially relevant to the case that they're investigating?
It does, but what I would say is I've obviously had the benefit of being at the inquiry and watching a lot of evidence and reading a lot of the literature. And in relation to that, in particular, some of the literature that has been published by Inquest, which we've had regard to. And I'm conscious that in relation to that, they have made a recommendation in relation to investigations, particularly in relation to deaths. And that recommendation is that in considering the death, particularly obviously of a minority ethnic person, it must be integral to the work of the oversight agency, so PIRC in this case, that consideration is given whether the role of race played any part. And I haven't really been, until I was reading these documents, I haven't had this level of understanding myself. And clearly, if that's the case, then I wouldn't anticipate my investigators might have that level of understanding. But what, and I know I'm sidetracking, I'm just going off your question here, but what we have put in place is I have asked the in-house legal head of legal services to actually revise our whole investigation template, and we will have a mandatory section in there which will, if it's race, it will be race, but if it's another protected characteristic, it will be there. And for her to draft more detailed guidance that supplements this and give examples of what we're talking about when we say stereotypes, or if there's any bias that comes through the statements, so reading the statements to ascertain that, to take account of the officer's complaint and a complaints history and disciplinary record. So we anticipate that has been put in progress, and anticipate supplementing this to give more explicit guidance on what we actually mean when we say stereotypes, racial tropes, and the kind of implicit biases that may appear. So looking at that, I accept probably this what is not detailed enough for to really assist to. It wasn't as detailed as it could have been for investigators, and so we have now taken a decision, and that will mean in every report, and obviously the final reports and deaths always come through myself, there will be a mandatory section where they will have to specify what they have actually done. And in that regard, having this discussion recently, my head of investigations has put forward that it may be beneficial for us to invest in some of our staff becoming particularly trained to be experts in this, and then there would be even an opportunity to have an independent person review the case after the investigator. So the guidance is there, but as part of the evidence at this inquiry and part of the literature which I've read that's come through this inquiry, I concede that it probably isn't detailed enough and it isn't explicit enough, and we will now be adding to that to make it clearer for investigators. What maybe I should say, since I've been in post, and I think there's been about 131 death investigations that PIRC have undertaken during that time. We don't. Up until last month, we don't record race as a matter of fact, although we will be doing that going forward. But we are aware generally, because I see all the reports, of the number of deaths involving persons from a minority ethnic community. We have only had one death that actually was where there was use of force involved, and that was the case that you alluded to earlier. The other 9 cases, 9 deaths, were all what we call indirect contact with the police, so there was no direct contact with the police. So in terms of actually having to look at this, we haven't, it's never come to me because I've never yet had to, apart from the case involving Mr. Bosch in Glasgow, I've never had to look at that, and it was a slightly different type of case. And maybe if I'd had a case like that, it might have prompted us to think about it earlier if we had enough guidance there. But we are aware of that and alive to that now, and we certainly are going to accept that recommendation that's been made by Inquest and ensure that that is integral to our work, and that we will put more training and guidance on what that actually means, so that we do hopefully satisfy that recommendation. So hopefully that might assist.
Thank you. So should we understand that as a result of documentation that you have read through your involvement with this inquiry, and in particular documentation that has come from Inquest, you have identified a need to go further than the PIRC already go, even in these detailed guidelines, and to provide more detailed guidance to your investigators? Will that be separate guidance, or is this guidance being reviewed? You mentioned it was currently under review because of the bill that's presently going through Parliament. Will it be part of the same review, or will there be separate supplementary guidance?
Our discussion the discussion has anticipated that, as I say, we will amend the investigation template, and there will be prompts in there, but it will be supplemented with bespoke guidance. But that's a fair point. It could maybe be incorporated into the actual guidance we've got here. The mechanism, we could consider that as the mechanism, but I think probably in the first instance we'd want to probably give quite specific examples, and maybe even have some kind of training or just discussion with it's certainly the senior investigators and the deputy senior investigators in the first instance. But yes, it may be that we supplement this with it, but in the first instance I think we would just want to draw attention to what is required in relation to what we need to investigate.
So here, for example, under this heading, what do you know? Are there any stereotypes or common assumptions made about the protected characteristic group that you are aware of, rather than relying on your investigators' own lived experience and any training they might have had the benefit of through PIRC? You're going to go further, I think,
yes,
and provide examples in relation to, for example, a black person, common racial stereotypes and tropes, so that if there is a deficit within the cadre of inspectors, and if they happen to be unfamiliar with certain of these racist stereotypes or tropes, then they will be very much put on their radar.
Yes, I mean, we have embarked on a suite of training programs in relation to EDI and unconscious bias issues, and we have had feedback from investigators and from our staff that we've had great interest and enthusiasm, but we've had feedback that they are anxious. They don't feel that they have got that expertise. It's not an area they've been particularly familiar with, despite having the training courses, understanding what direct discrimination is, indirect discrimination, but we probably haven't got that level of detail. And I think I said in my statement that what we tried to source for quite a long time was a lived experience training, because I think I had that many years ago, and I found it the most impactful when a person who's actually got the lived experience can explain how things affect them, in the same way as we watch documentaries about maybe a person in a wheelchair, and we go through a day in life and see all the barriers and how you don't even imagine the difficulties that they have. That's the kind of input we've been trying to source unsuccessfully. We thought we had someone from the IOPC, but unfortunately they left before it was delivered. So that kind of level of detail is, I think, what my staff are looking for, and the confidence then to be able to identify that. So I think they're familiar with the concepts, they're familiar with the requirements of the equality legislation, but it's more about having more detailed knowledge on what that actually looks like when you're reading a statement, and that's where maybe we'll invest in trying to even get some ambassadors that have that expertise, and we'll consider how to do that.
So is there an anxiety then amongst your investigators that perhaps because they don't have this lived experience themselves, and because they're not experts, they might miss something?
Yes.
Okay. And you've explained the ways that you're looking to fill that gap, to allow them to fulfil their functions with a greater degree of confidence.
Yes, I think there's no doubt that how we investigate race needs to be more nuanced and just more nuanced and more informed.
Thank you. Can you bear with me a moment? We sometimes take a break at around about 3 o'clock.
So we'll take a break for 15 minutes. Ms. Thompson.
I wonder if we can bring the guidelines back up on the screen, please. We were on page 16, understanding the allegation of discrimination. And we were looking at the various matters that an investigator should consider. Page 16, please. And we have looked at what does the complainer say and what do you know? And we can perhaps now move on to the third question in the guidelines that an investigator might ask themselves. What do you need to find out? In more serious cases or critical incidents, it may be appropriate to seek external expertise, for example, from an independent advisory group, a relevant community or advocacy organisation, or from a legal or academic expert. The investigating or review officer may also be able to usefully draw on findings from relevant inquiries, research, or reports about discrimination. In the case of the death of a black man following a police contact, would you expect your investigators to seek external expertise?
As I intimated, we've not had that type of investigation since I've come to post, but yes, it is something that obviously, learning from obviously this inquiry, that we would consider.
When you review your guidelines or consider issuing supplementary guidelines, do you think there might be a benefit in including suggestions as to where this expertise might be found?
Yes, I think the first stage for us to do is to try and identify where we can find that expertise. But yes, once we've done that, then obviously that would be included.
And would you expect your investigators to draw on findings from inquiries, research and reports, again in a case involving the death of a black man in police custody?
I think that's very much in line with the guidance that I was talking about that we are planning to draft in relation to our new requirement to have this addressed within our investigation. So that would be the type of guidance that we would be intending to issue to staff.
And again, would there be an intention on your part to perhaps signpost particular reviews, the results of inquiries and inquests that might be relevant in particular contexts, such as the death of a black man, a black person following police contact?
I think the guidance will be operational in the sense that it assists the investigators to actually respond to the specific areas that we signpost, that we ask them to consider. But an overview will be available which will explain the background, why we have added this requirement in, what type of information we're looking for, and certainly we'll provide an overview and an explanation so that it makes sense. We have an EDI group, and I would envisage that they would help again with that, pulling together that overview and then disseminating it and explaining it to staff.
Thank you. If we can return to the guidelines, we're on page 17. If we can scroll down a little. Here we are, examples of the type of investigation that may be required in relation to some of the protected characteristics are provided below. There then follow a number of examples, and the first is racism. In the context of complaints of race discrimination, it includes any discrimination relating to race, ethnicity, or nationality. The types of racist assumptions or prejudices that should be considered in a discrimination investigation will vary greatly depending on the particular race, ethnicity, or nationality and the context of the incident. There then follows an example, and I wonder if we might look at this example paragraph by paragraph. Allegation of racism made by a black man. Mr. A is a 19-year-old Asian man who suffers from Asperger's syndrome and autism. Mr. A says that when he was arrested by the police, they questioned him about why he'd come to the UK from Pakistan. He also complained that he was assaulted by the police when he was arrested. He considers that the police questioning him about his reasons for coming to the UK was motivated by racism, and that his Asperger's and autism meant that he was unable to effectively engage with the police, which contributed to the reason for his arrest. That's the scenario given in this example. The example then reads, to address the allegation of race discrimination, the investigating officer should ask themselves, and here are the suggested questions in line with the general principles set out in the guidelines. So, firstly, what types of assumptions, prejudices or bias might lead to an Asian man with Asperger's syndrome and autism being treated differently due to his race and resulting in the use of excessive force? Would a white man with similar issues acting in the same way be treated by those officers in the same way? So there are two questions there really for the investigating officer to consider. Firstly, assumptions, prejudices and bias that might have led to this young man being treated differently and to the use of excessive force. And then secondly, whether a white man with Asperger's and autism would have been treated in the same way. So the focus here is on race. So the who, if you like, is a white man with autism and Asperger's, rather than a white man who doesn't have those diagnoses. So the guidelines appear to encourage a focus on looking at assumptions and prejudices and bias that could potentially account for differential treatment. And then they encourage this comparative exercise where you look at how this individual was treated set against how a white man who didn't have these particular characteristics might have been treated. And so perhaps just taking a slightly different example, but working through how it might look from the investigator's perspective and the sort of questions they might ask themselves. If we had a scenario that involved a death following restraint by the police of a black man who was intoxicated or potentially experiencing a mental health crisis, what sort of questions might the investigator be asking themselves? Would they again ask themselves about assumptions and prejudices and biases that might have led to this individual being treated differently?
The investigator, what is envisaged is the investigator will look at all the evidence that's been gathered and will look to see if there's particular language used that would provide inferences. They would look at the conduct of the officers, and as I've already alluded to, they would perhaps look at the complaint and disciplinary record, conduct record of officers to see if we've got other examples or comparative examples where they have acted in that manner. They would look at all the evidence that's ungathered in investigation, because that's all the information they've got to do that. So that it's not about the investigators making assumptions, it's about looking at the evidence that they gather to see if there's any legitimate, as I say, stereotypes or assumptions or coming through from the evidence in the same manner perhaps as there has been in looking at the statements in this case.
And that would involve the investigators being alive to stereotypes to begin with. And as you've already explained, you're looking to develop the guidelines to ensure that where there's perhaps a deficit in lived experience or professional experience and training to date, then the investigators will understand the different types of stereotypes that are associated with the different protected characteristics.
Yes, as I've said, we're going to supplement the training that has already been rolled out by having more nuanced training on what exactly kind of language we're talking about, what kind of assumptions are we talking about, what should they be looking for, and providing more operational guidance than just saying, look out for stereotypes.
Thank you. Returning to the example, Mr. A has made an allegation of race discrimination. He has also complained that he was discriminated against because of his Asperger's syndrome and autism. This should be recorded and considered as part of the investigation with attention given to whether Mr. A was treated less favourably because of both his race and Asperger's syndrome and autism. So here the investigator is being encouraged to consider whether there has been discrimination on grounds of race and potentially also differential treatment because of the individual's Asperger's syndrome and autism. And again, if we were to use a subtly different example, the death of a black man following restraint who was intoxicated and potentially also experiencing a mental health crisis, would you anticipate investigators looking both for evidence of race discrimination and also differential treatment because of the individual's state of mind at the time?
I envisage going forward that in a death of a person from minority ethnic group that we will be looking in relation to all of those aspects.
Thank you. That paragraph reads that this should be recorded, that is the gentleman's complaint of discrimination should be recorded and considered as part of the investigation with attention given to whether he was treated less favourably because of both his race and his Asperger's syndrome and autism. Where are these matters, these concerns recorded? You mentioned earlier the existence of templates. Is there a particular pro forma to an investigation report?
Yes. The investigation report is a pro forma with different fields that have to be completed. So, background. I'm talking about a criminal one. The background of the offence, the charge, the narration of evidence, CCTV evidence, airwaves, etc. Analysis of evidence, obviously concluding with a conclusion whether there's sufficient evidence in relation to criminality. So we have templates that we have adapted since I've been there, incorporating different fields and different aspects of the investigation. So that would be where it would be recorded in the actual body of the investigation, as because that's the appropriate place for it to be recorded. So that's where I envisage it. That's where it would be naturally. What we're doing is making a specific field that actually focuses people's mind, and that we expect in such cases that we will undertake this an investigation taking account of these kind of factors, and there will be something recorded in the investigation. Whether that concludes that there was no evidence of any of that, that should be recorded, and what the basis for that is as well.
And is that a work in progress, the revisal?
Yes,
of the
this is something, as I indicated, that we have discussed following reading some of the literature that's come out, and it's really an attempt to try and address that recommendation, to try and make it part of our integral investigation, to identify racism and thereafter to respond to that. In terms of that, I think that's certainly a starting point for us would be to have it in the body of our template, and then that will be supplemented with guidance of what kind of thing. What are we looking for evidentially? Where can you draw these inferences from? And that's the bit that still has to be drafted and maybe quality assured by experts. But I think that's my first effort at trying to meet that, so that it is included in reports. And as I say, we have for these kind of cases, there's a quality assurance process that will go through Head of Investigations, Director of Operations, and then ultimately myself. So we would expect by the time it gets to me, I would expect there to be that part of the template completed. So that's where we think we can. That makes more sense because it is part of the investigation if we want it to be an integral part.
And do you have a timescale in mind for the revisal of the templates and also for the issuing of your supplementary or revised guidelines?
The revisal of the template is straightforward. I think making sure we get the guidelines right and then having some kind of quality assurance process will take a bit longer. I haven't got a fixed time scale in my mind, but it has been agreed that we'll do that with the senior management team, so it will be taken forward in the first instance by the Head of Legal Services.
Thank you. And in relation to the templates, do you envisage one pro forma template that applies across the board to all investigations, which will have a section intended to ensure that the investigator has addressed their mind to the possibility of discrimination? Or is it the case that there's a separate template for cases in which an allegation of discrimination has been made, where that will be explored in more detail?
No, it would be in all of the templates. We have a different template for investigation of deaths and investigation of allegations of crime. It would be on all the templates.
So in every single case, then, there will be a requirement for the investigator to consider whether there's a possibility that discrimination is a relevant factor in the case.
To make sure they're alive to that, and then they take that on board when they are in gathering evidence. That will be something that is there that will hopefully ensure that that is undertaken and that we go some way to addressing that. I'm not saying that's the full way. It's where we're going to start.
Thank you. Let's return to the example in the guidelines. We're at the very bottom paragraph on this page. This is a serious allegation, and the investigating officer is aware that the case has similarities with a number of high-profile cases involving issues of restraint, health and race. Given this, the investigating officer puts in place support measures, including involving the family of Mr. A, to ensure that he can effectively communicate his complaints. Would you envisage support measures being put in place where a black man has died following a restraint by the police and concerns have been raised by his family that race was a factor? Is that the sort of case where support measures might be put in place for the family, and if so, what would you envisage?
In the case you've described, we would have obviously employed flows, and part of the responsibility of the flow is to provide support and be a conduit for information to go from the family back and forth, and they are the mechanism for the family to express concerns. Again, as I've said, depending on the circumstances of the incident, it may be that the senior investigator or someone dealing more directly with the case, the family may wish to speak with them. So we will put, in all cases, the flows in, and we would like to think that they would be able to support the family, but we would take into account individual circumstances.
Thank you. Again, returning to the example, drawing on background information and the details of the discrimination allegation provided by the complainer, the investigating officer identifies a number of questions to be addressed through the investigation. So the guidelines are certainly the working through of the guidelines in this example envisage the investigating officer setting themselves questions that require to be answered. And in this example, these questions include: were officers aware, or could they have reasonably expected to be aware, that Mr. A had difficulty engaging at times of stress due to his Asperger's syndrome and autism? And I'm wondering, again, if we come back to the alternative example of a black man who has died following restraint by the police, who was intoxicated and potentially also in mental health crisis, whether the sort of question that an investigator ought to ask themselves here might be along the lines of whether the officers could have reasonably been expected to be aware that this individual was intoxicated, whether they could reasonably have been expected to be aware that they were potentially experiencing a mental health crisis.
Yes, these are questions that are asked in death investigations at present.
Thank you. Returning to the example, another question that the example suggests the investigator should ask themselves is what assessments were made to take account of Mr. A's Asperger's syndrome and autism? How was this reflected in the actions taken? In light of Mr. A's challenges, was it appropriate for Mr. A to be arrested and taken to a cell? Would a white man with similar challenges have also been arrested in these circumstances? And again, I wonder if we return to the scenario that we've been discussing involving a black man, whether the sorts of questions that the investigator might be asking themselves here would be along the lines of what assessments were made of the individual's mental state, how was that reflected in the action taken, was it appropriate for him to be restrained in the manner in which he was, and would a white man with similar issues have been arrested in these circumstances?
These types of questions are asked in our death investigations. We look at, in the death investigations, whether the officer could have taken other options, and we will ask why you've chosen this option, why did you discount that option, etc. So that is something that we regularly explore when we are doing a death investigation. It's included in the report, an explanation of why, for example, the use of taser wasn't appropriate and why this was appropriate. So we will explore the different uses of force and why they excluded one and why it didn't. So that is something that is currently something we would take into account when there is a use of force, and we would look ourselves at that explanation. We may have body cam footage which allows us to kind of compare what the officer said with what actually happened. So that kind of investigation is something that we do as a matter of an investigation of this nature anyway.
Okay, thank you. Again, returning to the questions posed in this example, what assumptions were made that Mr. A's behaviour was a result of drug-taking, aggression or criminality, rather than symptoms of Asperger's syndrome and autism and a reflection of vulnerability? Would similar assumptions have been made if he was a white man? And again, I'm wondering if we jump to the parallel example we've been discussing involving a black person who's died following a restraint, whether those questions might translate along the lines of, were assumptions made that his behaviour was a result of drug-taking, aggression or criminality, rather than mental health crisis and a reflection of vulnerability? And would similar assumptions have been made if he was a white man? Are those the sorts of questions you might anticipate an investigator would be asking themselves?
These are questions that investigators do ask in circumstances as you've described. In all investigations, I would say that they are seeking to ascertain from the officers the reasons that they acted in a particular way. What was their understanding of the person's mental health? What was their understanding of intoxication, etc.? So that is something that would be regularly addressed by investigators when they're speaking. What was your understanding? Why did you do this? And the officer may say, I thought he was intoxicated, or appeared to be on some kind of illegal substance. So these questions are something that we would ask in general in relation to all death investigations, particularly if it related to something that person ended up dying in custody. There's a very thorough explanation that would be looked for every single aspect of the time that they are in custody. Why did the police take such actions? What were they doing in relation to observations? So these kind of areas will be explored by investigators, and police officers will be asked why what was their belief at that time, because we're looking for them to explain why they did certain things, and then we can assess whether, in terms of the law and the circumstances, whether that was probably the right option or there was other options that they could have taken. So these would be questions that we would already be asking.
Thank you. Returning again to the questions posed in this example, were assumptions made that Mr. A posed a greater threat or risk because he was Asian and did not effectively communicate? Were assumptions made that he was particularly strong or more likely to resist or to be violent? Would the same assumptions and risk assessment have been made if he was white? And are these, again, the sorts of questions that an investigator might be asking in the case of the death of a black man following restraint by the police?
Yes, and I think this is the area that I've talked about that we'll probably be providing further guidance on to assist investigators assess whether the language does reflect sort of stereotypical language, etc. So I think this is the area where we probably do need to supplement our existing guidance.
Thank you. The next question posed in this example is there any indication that the officers involved hold negative views of Asian people, or that Mr. A was targeted because of his race? And I'm wondering if in the parallel example we've been discussing involving a black male, whether you might expect the investigating officer to be asking the question, is there any indication that the officers involved hold negative views of black people, or that the deceased was targeted because of his race? Is that the sort of question you would expect them to ask?
I think they would be unlikely to get a response that would be helpful. I think more likely we'd be looking at the evidence. For example, we might look at the officer's conduct record to see if there's any parallels or any concerns that have been raised in other cases. We may look at, as I say, conduct and complaints that might be made. Is there any themes that we can draw out of that? So I think we would be looking at the evidence as a whole to see if there was an inference that could suggest that. I'm not sure we would get much joy out of just asking an officer if it was because of they had a particular, an assumption or hold negative views. But I think you'd have to be slightly more nuanced in how we do it.
Sorry, that perhaps I wasn't terribly clear there. I understand that these are questions in this example that the investigating officer should be asking themselves and looking to address broadly in the course of the investigation. I'm not suggesting that these particular questions should be put to the officers concerned. It's entirely my fault if that wasn't clear. But the question of the approach to be taking to questioning an officer, I think, is explored in the next chapter. So this might be a convenient point at which to turn to chapter 6, which is headed up Conducting an Investigation. This starts on page 31. So the purpose of that exercise, Ms. Macleod, was really just to look at the example given in the guidelines, which, if you like, brings the principles to life. And the example suggested that the investigating officer should be asking questions of themselves and of the investigation broadly. I was really just looking to explore the sorts of questions that they might be asking themselves in the example that is more perhaps pertinent for today's purposes concerning the death of a black individual following restraint. So let's look then at Chapter 6, Conducting an Investigation. Investigating and review officers should have a detailed understanding of equality and diversity issues and an appropriate level of knowledge, skills and experience to be able to apply these guidelines and undertake effective investigations. Terms of reference. The terms of reference for an investigation into death or serious injury that raises issues of discrimination should explicitly refer to and address any discrimination allegations raised. This includes where discrimination is alleged as an aggravating factor in relation to separate criminal or complaint allegation, or where no specific allegation of discrimination has been made, but it is apparent that discrimination may be a relevant consideration. So we see here it's set out in terms the expectation that even if an allegation of discrimination has not been made, an investigator should be alive to the possibility of discrimination being a motivating factor, and if apparent discrimination may be a relevant consideration, that should be captured within terms of reference. Now, who sets these terms of reference?
The Crown do.
The Crown. So we're looking here in particular then at Crown-directed investigations.
Yes, yes, in relation to death investigations, yes, the Crown will set the terms of reference.
Okay. And would you expect then that the need to explore any possible or apparent discrimination, whether that relates to race or another protected characteristic, would be set out within the terms of reference provided by the Crown to the PIRC?
Yeah, the Crown set out a number of questions that they wish the investigation to examine and to include in their findings and in the report that goes there. So they set out various questions that basically we would have to address.
And what would the PIRC do if it was apparent that discrimination may be a relevant consideration, but there was nothing in the terms of reference?
We would raise that with the Crown and explain that it would be helpful if they just amended the terms of reference. We have regular meetings at both strategic and at practitioners level with the Crown, and we have probably a very healthy dialogue about cases, so there would be absolutely no issue in phoning and discussing and saying we think maybe it would be better to include this in the terms of reference, and I have no doubt that that would be taken on board.
If we can return to this page and scroll down a little, please. That's perfect. Just above the heading in purple, the text reads, all allegations of discrimination arising in complaints, death and serious injury investigations or criminal investigations should be dealt with according to this guidance. So this sets the standard, this sets the expectation that falls on the shoulders of every investigator who is carrying out an investigation, in particular in relation to a death, that they will comply with the terms of the guidelines. If we move to the paragraph beneath the heading, Understanding the Allegation of Discrimination. At the beginning of an investigation, the investigating officer should take steps to build their understanding of the discrimination alleged, including the types of assumptions, prejudice or bias that might have informed the police officer's decisions, actions or behaviour. This should inform the lines of inquiry for the investigation or matters to be examined in the complaints review. So again, there's a focus here on the investigating officer at the very outset taking steps, so proactively taking action to build their understanding of the discrimination alleged, including the types of assumptions, prejudice or bias that might have informed behaviour and actions. And as you've already explained in some detail, you're looking to enhance the guidance to give examples of the sorts of stereotypes that exist in relation to assumptions and prejudice and bias around race and other protected characteristics. And if we can move on to the next page, please. At the top of that page, under the heading Conducting the Investigation, the understanding acquired at the beginning of the investigation to consider how the alleged discrimination might present and what stereotypes or prejudicial assumptions might have informed the officer's actions should inform the key lines of inquiry. So that early understanding is pivotal, yes, really, in terms of setting the direction of the inquiry. Indeed. And key lines of the inquiry. If we can perhaps look further down the page, I'll read it short, but if we pause there, please, in fact, scroll up just a little bit. Thank you. The paragraph at the top of the screen highlights standard lines of inquiry in all cases to try to find out what happened and why. So that involves witness statements, CCTV evidence and gathering productions and so on and so forth. If we scroll beyond that, an investigation will need to consider whether there is other evidence that supports the allegation of discrimination. And this includes complaint history and patterns of behaviour. Mm-hmm. Patterns of behaviour are important to consider in discrimination cases, as an instance of discrimination may reflect an attitude or underlying prejudice that may arise in the person's behaviour across a range of situations. And there's a suggestion that the investigating officer might look at an officer's complaint history, for example, and also, if we carry on into the next page, please. So complaint history, patterns of behaviour, and also comparator evidence. What's the value of looking at the complaints history and patterns of behaviour and comparator evidence?
Well, we do look at complaint history in our investigations, and the purpose is to see if there's a course of conduct, to see if there's a pattern, as is indicated in the guidelines, of a particular officer behaving in a particular way. There may be, for example, the possibility of using Murov doctrine, and we might look and see if there's the pattern there that might inform whether there's been similar complaints, and we can assess whether we want to look and see if the behaviour fits within the criteria for Murov. So, but mainly if there was a particular type of complaint that was in there that was obviously indicative of a particular assumption, then that would obviously raise concerns, and that was something that would be featured in the report. So we do already look at complaint history when we're looking at investigating police officers.
Under the heading Comparative Evidence, the guidelines state, in most cases, deciding if there has been discrimination will involve comparing how the complainer was treated against a person in the same situation who does not have the same protected characteristic. Investigating and review officers should look for evidence that supports this type of comparison. So I'm interested to understand, again, if we use the example of a black man who's died following restraint by the police, and there has perhaps been an allegation of excessive use of force made, would this sort of comparative exercise perhaps involve looking at how that officer or officers have responded in similar situations involving white individuals?
No, there's no real mechanism to identify similar cases if they've not come. Obviously, if we have cases reported in the same officer, we can look at those and compare and make inferences from that behaviour. But if I have a report, there's no way for me to know how that officer has behaved in relation to similar circumstances involving a white person, because as I say, unless it's come in relation to the officer, and we can identify when that does happen. So we have cases like that, but no, I wouldn't have any mechanism to find out how they behaved in relation to another person. In any of the cases that come in, there's no real mechanism for me to do that.
Would you have access to things like use of force forms?
We have use of, we get use of force forms in each of our investigations, but I wouldn't, so if I'm investigating an officer, I get the use of force form for that particular investigation, but I don't know if that officer's had a use of force form in another case, etc. That's not something, unless I have a case before me. I can't just randomly go and ask for all the use of force forms in relation to a particular officer. I'd have to have some justification to do that, but we've never considered that appropriate.
Can we move on to, I think it's the next page, page 34. And beneath the purple box, there's a heading, Discriminatory Language. As part of the consideration, the investigator and reviewer should assess the language used, including language used in any records relating to the incident in question or arising from the complaint investigation. This includes any use of obviously discriminatory language, but also more subtle indicators that a person may have acted or made a decision based on prejudicial assumptions. There are terms that are commonly recognised as being offensive, and officers and police staff members should be expected not to use them. However, there are other words and phrases which are inoffensive in themselves, but when heard in court can reasonably be thought of as discriminatory. So should we understand then that the investigators are encouraged to look at language that has been used by officers and to examine any statements that might have been given for the use of language that might suggest a discriminatory attitude?
Yes, so that as I've probably indicated, will be covered in the guidance that's been drafted.
I wonder if I might give you one or two examples from the evidence that we've heard in connection with the death of Mr. Bayo. I'm interested to know whether these examples are the sorts of things that you would expect an investigator to take into account. I'm not looking to invite your comment on what they might make of this language. I'm simply interested to know whether it's the sort of language that you would expect to stand out to them and be examined as part of their investigation. So we have heard evidence that Constable Walker, who was one of the first two officers at Hayfield Road, that he said it crossed his mind that Mr. Bayo was doing this to get the police there, bearing in mind we're on a severe threat level for an attack on the police. And Constable Payton similarly said, it ran through my mind that this male could be part of a terrorist plot. And later in the evidence, he said, I kept thinking about the Lee Rigby boy, the soldier who was killed. Is that the sort of thing that you would expect your investigators to consider as part of their examination of the evidence and their consideration of whether there had been discrimination?
These are, that's an example that I understand that the inquiry has focused on, and is indicative of maybe of a bias in relation to the officers. So yes, in terms of that would be something that we would signpost the investigators to. Why in particular was there an assumption that was going to be a terrorist attack? So yes, it is. And in the other, as I say, I've listened to a lot of the inquiry, and I've recognised the examples that have been asked various witnesses, that you have asked various witnesses, which in themselves on their own maybe not, but when you push them together in relation to all of the other evidence, maybe form a picture. So and it's on the basis of that I think that we need more nuanced guidance, because that's not at the moment contained some examples in the guidelines, and it's something that we probably need to just have more guidance around. So yes, I accept that some of the terminology that's come out in the inquiry is what we would be looking to identify.
Again, you may have heard this before, because I'm mindful that you have sat through much of the evidence that the inquiry has heard. But we have heard evidence that some of the officers used language in their statements such as coloured, zombie, deranged, superhuman strength, and the biggest male I have seen. And that last comment was in the context of Mr. Bayo being approximately half the body weight of Constable Walker. Again, is that the sort of language that you would expect your investigators to pick up on and take into account as part of their examination of whether there was evidence that was suggestive of discrimination?
In relation to an investigation where there's an issue or race is in focus, then yes.
Thank you. I wonder if we can return to the guidelines and go to page 35. I said we would return to the guidance given in relation to taking a statement from the officer who is the subject of the allegation of discrimination. And if we scroll down a little bit further, please, to the heading Probing the Officer's Account. Here we are. In discrimination cases, it is important to get an account from the officer and to test and probe their account. While the officer is not obliged to provide a response, if they do not give their version of events, the complaint may be upheld in absence of any other material. Direct closed questions such as, did you discriminate against the complainer, or did you treat the complainer differently because they were black, etc., are unlikely to be very helpful. And that's essentially what you were saying earlier in your evidence, when we were perhaps slightly at cross purposes. Investigating officers should refer back to the thinking done at the beginning of the investigation to consider what stereotypes or prejudicial assumptions might have informed the officer or staff member's actions. Questions should be asked to test whether these sorts of assumptions informed their decision making. And if we go a little bit further, we'll see that questions should focus on why the officer undertook the actions they did, what assumptions were made, and what were the reasons for these. It's not enough that an officer provides a reason for their actions. The investigating officer needs to be satisfied the reasoning is sound, convincing, and fair, and not informed by prejudiced assumptions. And there's then an example, and we'll look at this briefly in the purple box below, of the sorts of questions that might be asked. So here we have a scenario. It's an allegation of discrimination and use of excessive force, and the investigating officer is looking to test whether a police officer made prejudiced assumptions that the complainer and Mr. C posed a greater threat or risk because he was black. Questioning should look to probe what the basis of the risk assessment was, whether this was reasonable in the circumstances, and whether the actions taken appropriately matched the level of risk identified. And questions are suggested, which include, what was your first impression when you arrived at the scene? How did you assess the risk of harm? What things did you consider? How did you take into account the level of risk in the way that you approached Mr. C? What were your options, and how did your thoughts about likely risk impact on what you decided to do? When you decided to restrain Mr. C, what did you think this would involve? Were you surprised by his response? Did anything happen to change your risk assessment at any stage? And if we could just scroll down a little bit, please. If the risk assessment is found to be unreasonable in a way which is consistent with the stereotype view of black men as being more violent, unpredictable, or aggressive, the investigating officer will need to weigh up the likelihood that the reason for this relates to Mr. C's race, as opposed to any non-discriminatory reason offered for the officer's actions. So again, this is simply a worked up example of the principles in action, as it were. But again, using our example of a black man who has died following restraint by the police, are these all relevant questions? Are these the sort of questions you would anticipate your investigators asking of the restraining officers?
These are all questions that would presently be asked in relation to officers in a case where restraint was involved. I would be expecting these to already be covered by investigators.
Thank you. You sat through the evidence, Ms. Macleod, and you'll be aware that when the PIRC noted statements from the officers involved in the restraint of Mr. Bayo on the 4th of June of 2015, the interview strategy didn't touch on race. Should we understand from what you've said today in your evidence that if a similar death occurred tomorrow, your investigating officers, in putting together their interview strategy, would be asking these sorts of questions?
Yes, in investigations now, one of the yes, you're right. I have identified through the inquiry that there was implicit or explicit criticism of a lack of analysis of the use of force. That is something that I think would be addressed now. One of the measures which we have done this year is we have recruited a reports manager. She has a legal background, in fact, a background in the fiscal service, and her role is specifically to assist investigators with analysis of evidence. She's got a mentoring role with the investigators, but also a quality assurance role. So she started in March this year, and specifically we have taken on board the criticism that there was not enough sufficient analysis regarding the use of force, and if we had a similar case, I would anticipate all of those matters being addressed. We also have recruited investigators who have got specific skills in the interviews. Can't remember the terminology, strategy. And so I would imagine that we would be in a better place to address those questions. Again, PIRC is really an investigative agency. It's not full of lawyers. The Crown makes the final decision, obviously, on sufficiency of evidence, but we do wish to increase the quality of our reports in relation to the analysis of evidence. So that is one action that we've done to do that, and hopefully that mentoring will permeate in our quality of our reports, and we will ask more detailed questions in relation to the use and more comparative of the different statements that we have from the officers. So that is something, again, that we have been focused on, but also a part of it has arisen from listening to the evidence in this inquiry.
Thank you. Can we move to page 39, please? This is headed up Findings and Outcomes, and I'll perhaps read this short because I'm mindful of the time. But essentially here it appears that investigators are being encouraged to look at the evidence in the round in its entirety, and to return to the question whether a person without the protected characteristic would have been treated the same way, and they've to provide an evidence-based response to that question. I wanted to conclude with just a few questions around the documenting of their conclusions. You've mentioned templates. How are these decisions recorded?
Sorry, decisions in...
A decision, sorry, once the investigating officer has completed their investigation
Right.
into an allegation of discrimination, how are their findings in relation to that investigation recorded?
Okay, well, in an investigation, obviously, the complaint handling review, there's a report sent to the person, so there's a report and they have a full report of the findings of the complaint handling review. An investigation, at the end of the report, if it's an investigation into criminality, there's an analysis of evidence which covers all aspects of the evidential considerations in the case, and basically the primary purpose of that is to advise whether we believe there's a sufficiency of evidence, and perhaps to add commentary whether there was any mitigation, or and commentary about whether there was anything of this nature, which, as I've explained, we now will have a mandatory section, which, if there is anything there, will be reflected in the conclusion and the recommendations, and that will go to Crown.
Thank you. How do you monitor compliance with the guidelines?
Well, as I indicated, since I've been the Commissioner, we've only had one case that involved force and restraint, and it was a particular set of circumstances. The other cases that we've looked at, as I've already explained, were more about indirect rather than direct contact with police officers. So in terms of looking at race, there's probably not been... The investigation report hasn't really had to focus on that aspect because there hasn't been, as I say, any direct contact with the officers. In fact, in many of the cases, the officers didn't know what race the person was. So, for example, if I can just give you a quick example, we may investigate if somebody has called in distress to the police, what the response time is, how they graded the call, how they actioned it, etc. We might be asked by Crown, was that appropriate, etc., because the person may have been found deceased elsewhere. So the police haven't actually come in contact with the person. We're looking at whether they could have taken different actions and there could be preventative behaviour there. So we haven't really had many cases that I could really answer that question. There's more in the complaints handling where there's more allegations of discrimination, and that can be along the lines of any of the protected characteristics. There's more variety, but there is more scope for people to claim that they've got been discriminated because of one of the other protected characteristics. So in that section, there is a section in the complaints handling where somebody can record that they think they've been discriminated due to a protected characteristic, and that will obviously be taken into account by the review officer. And as I say, at the end of the day, the product from there is a report which goes back to the person. But we're looking at how the police handle it. We're not looking how they've investigated it. So I think there's probably more examples of that in relation to the complaints handling side of our work than there is in the investigation side.
Thank you. One final question. We've heard evidence about the composition of your workforce in 2015, particularly amongst the cadre of investigators. How many or what proportion of your current investigators have a policing background?
62% of the investigators have a policing background, and 45% in PIRC as a whole have a policing background. Now, that could be policing, or it could be military police, or it could be other policing bodies as well. It's not entirely made up from Police Scotland, but that's the percentage that I was informed that we are currently sitting at.
Right, thank you. Can you bear with me a moment, please? I have no further questions. Thank you.
Are there any Rule 9 applications? Ms. Macleod, I wonder if you'd withdraw to the witness room while I hear a submission.
Thank you. It's one very brief issue. We heard in earlier evidence from investigators that there was a system of self-referral if they had former working relationships or worked together or members of a same group or associations as the people who were being referred to them to be investigated. And what I'd like to ask this witness is, to ensure that there's a procedural safeguard to ensure proper independence, would it be helpful to have a register of interests to ensure that when cases are being considered by investigators, you can see independently that they are independent from those they are investigating?
Well, thank you. I shall allow you to ask that. Mr. Scullion, do you wish to pursue any lines of... thank you. Yes, very well. With the witness back, please.
I've had a huge pay. No, we saw it.
Ms. Macleod, Ms. Mitchell KC, who represents the families of Sheku Bio, has a matter for you.
There's just one issue I'd like to raise with you, and it touches upon the fact that former police officers make up 62% of your investigators. We've heard in evidence before that the way somebody identifies whether or not there might be a conflict of interest between the thing that's being investigated and the investigator, be it a former work relationship they had or membership of the same group or association, that matter is one of self-referral. The investigator thinks about it, decides whether or not it's going to be problematic, and would flag that up and someone else would be assigned the job. First of all, is that still the same? Is it still a matter of self-referral?
Yes, well, there's a code of conduct that specifically states if you have any connection that you have to excuse yourself. In addition to that, the allocation of cases, the head of investigations is aware of the background of all of the investigators. So if there was an allegation in a relatively small area where we knew one of our investigators had been located, then they would deliberately ensure that they weren't asked to go and take over that investigation. We're a pretty small team, 65, so there's a good knowledge of the background of all of the investigators. In fact, not 65 former police, whatever 62% of that is. So there's awareness, but they are aware that they have to excuse themselves if they have any relationship or knowledge or association with any of the people that are involved in the investigation.
So what the person who's allocating the work does is they know to a degree what that person's work was, where they may have worked, etc., and try to avoid that. Would also be helpful to have a register of interests to ensure that there's a procedural safeguard in place so that can be independently considered.
What?
But a register of interest so that what you can do is identify when if someone is a member of a club or a group or have worked somewhere for a particular time or have worked in a certain area, then that is independently written down so that if it comes to checking whether or not there could be any connection between people, there's some independent way of doing that, rather than relying on self-referral or relying on what someone knows about somebody who's been in the police force.
I understand, but I'm struggling to contemplate if there was a register of numbers of clubs or places they'd been. When we get an investigation and we don't know the officers, you know, how to marry that I'm struggling to find how that would be how we would operate that.
Just for example, if an officer from a certain division within Police Scotland is referred, and the officer who is looking at their inquiry isn't from the same group, doesn't have any connection with them, but is perhaps member of the same I don't know, a bowling club or something like that. I'm just providing an example. Would it be a good idea to have a register of interests so that it would A, focus the mind of the person that's considering the matter, and B, be allowed to be able to be checked independently of that person making the decision or the person, the source of knowledge who's allocating the work?
I understand where you come from, but the difficulty would be that we would know that the senior investigator was a member of this bowling club, but we would have no idea from the paperwork that the officer we're investigating was the same, was a member of that bowling club. I think, and what I would say in my experience is, I think I've only had one incident where I had concern about who we'd allocated to the case, and it was precisely because that area, they had worked there, and it was a small town, and we thought, even though none of the people that would be investigated were anybody he knew, we thought for propriety it was better that it was given to someone else. Again, the numbers are really small in PIRC, and there's 16,000 police officers, so the actual times where this has become a concern has been, I could count on one hand or less than that. And I know it's reliant on sort of people identifying that. But I do have confidence in the investigators that they understand the need for independence, and they understand their obligations. And as I say, I haven't had a situation, and it wasn't because I had any concerns about the officer, it was just because of the perception of it, and that he'd worked there, that I decided that it was probably better that somebody else take over that.
No further questions.
Thank you. Well, Ms. Macleod, thank you very much for coming to give evidence to the inquiry. I'm very grateful for your time. We're going to adjourn now for the day, and you'll be free to go.
Thank you.
10 o'clock tomorrow morning.